So there we go. So we started the recording. All right, everybody, thank you for being here. Welcome to our December meeting of the PRC. Hopefully everybody has a copy of the agenda and a revised version of the minutes prepared by Peter. We have regrets today from John, from Peter. So thanks to Brendan for agreeing to take the minutes. So thank you, Brendan. And let's see, and Matthew. Matthew can't make it today either. So we have those regrets. All right. So everybody's hopefully seen the agenda. Can I have a motion to adopt the agenda as circulated? Howard, a seconder? Can I have a seconder for the motion? Oh, Irving, thank you. All right, all in favor? Carried. Thanks very much. And likewise, can I have a motion to approve the minutes of November the 8th, please? Stefan, thank you. Seconder? Howard, thank you. And approval of the minutes? All right, again, thank you very much. Okay, so moving forward, let's go to our news and announcements. Some of the material that you have in the agenda is a repetition of last month's meeting. So the first thing we have was the decision of the Supreme Court with respect to life without chance of parole being cruel and unusual. Peter was going to prepare something for that. I don't have anything from him indicating that he has something ready for us. So obviously we'll wait till next month till hopefully Peter's back with us. The other next issue is Howard's pro bono students. Howard, is there anything to add to our minutes from last month?
You're muted, Howard.
Yeah, there we go. Sorry. No, just nothing new to add, just that they're working away we've narrowed the topics down primarily based on their interest, but also subject matter that I think would be of interest to the PRC and have a sufficient legal content. So one student is going to be doing a research paper on us. It's a word I don't like to use often, but intersectionality of remand populations in Ontario with indigeneity and unrepresented accused. So again, the focus is the notion that the remand populations are way too high in Canada as a percentage of provincial population and too high in number. In addition to that, some of the things that contribute to the remand population we suspect are unrepresented accused. And then also we know Indigenous people are overrepresented in every aspect of the justice system, and that extends to remand populations as well. So we're looking for some good up-to-date data on that. Brendan, if you know of any, please send a link my way. I was trying to connect with Justin Pichet, but he hasn't returned any of my calls or emails. The other student is doing a brief for us on intimate partner violence, and you may recall the Justice Committee in the House did a study of the notion of extending the criminal code to include precursor kinds of behavior to intimate partner violence, and there's a private member's bill on it, and she'll be doing a brief on that. So we should look to see something from them in the new year, probably not towards the end of their term, so probably not until March, but I'd like to invite them sometime in the new year to one of the PRC meetings so they can get a sense of our discussions and the flow of our consideration on that matter. And Miles, I'll check in with you to firm that up, but that's kind of where we are now.
Yeah, sure. Students coming to the meeting, more than welcome. So that'd be great. Next, we had from the last meeting. Oh, Kyle, your hands up.
If I may, I'd just like to ask a friendly follow-up question to the work of the students. Actually, maybe it's one question, one comment. The first one being, is the work envisioned for the students like really kind of, we frame it, is it just a research in terms of like the current state of affairs, or is there also an appetite to explore Like I'm just thinking solutions or concrete policy or programming alternatives. I raise it only because I fear getting stuck in a perpetual state of, we need more work on this, we need more analysis without a lot of folks trying to advance the conversation in terms of what to do. So my friendly, I guess, question, but a hidden suggestion would be to make sure that the kind of solution side of the puzzle is also explored. And at the same time, I just wanted to make a link to, I know that there was some disaggregated data work that the Policy Review Committee provided comments on that StatsCan was doing. So maybe there's an opportunity to follow back up on that work if it could be helpful in the context of this remand research. So just friendly observation, but then trying to make links with some other work that this table has done. Thank you.
Thanks, Kyle. Okay, Howard.
On to that just briefly.
Sure, please.
Yeah, Kyle, yes, of course. There isn't a project, actually, it's a little bit of a curse. There isn't a project I get involved in that I don't expect some consideration or discussion about future steps, solutions, where we go. On the intimate partner violence, the young law student is looking at whether there is actually a good argument to increase legalization, or whether that extension of the criminal code prohibition is actually problematic in many ways with respect to intimate partner violence. The Standing Committee was pushing it. The Justice Department's response said they were considering it, but there's a real potential downside of that. So yeah, we're looking at policy commentary and response and consideration of future directions. On the remand population, as you may know, that the Stats Canada, of course, as a national body, looks more at the federal correctional setting rather than provincial populations. I was able to find some references to remand populations in that, and I think the Public Safety Canada annual corrections report, but there is not a lot of data in the hands of federal people on remand populations, and disaggregated data is even more difficult. So those are some of the things we'll be thinking about and commenting on, and actually looking for alternate sources, which is why I tried to contact Justin Pichet, because his expertise is heavily into provincial institutions. So, but Kyle, your points are extremely well taken, but I hope our two students' projects will respond to your comments and suggestions, and I invite you to make sure you give us some comments on it. I think we'll be circulating draft products, and by all means, I look forward to the input of everyone around this table as we try and fashion a product that's useful for the PRC, with a view perhaps to future steps. The draft brief is something we might well want to submit at some point to ministers, even though it's on a private member's bill. It's certainly worth trying to nudge our federal ministers along. So anyway, thank you for those comments.
Yeah, thank you, Howard, and thank you, Kyle, for again those comments as well. The other issue that we dealt with last month in some detail was the Supreme Court's decision in Sharma as it affects Indigenous offenders and the utility of sentencing regimes like conditional sentences. Does anyone have anything to add to that particular discussion from last month? Okay, thank you. I put a new issue on as a function of news, basically dealing with amendments put before the Public Safety and National Security Committee, dealing with amendments to Bill C-21. It was a 428-page amendment, as it turns out, regarding the firearms that would be included in that particular piece of legislation. Rob, were you going to be talking about that when we do your parliamentary committee, or do you want us to do it now?
I was not. You can do it now. I wasn't going to go into that level of detail. I was aware of that 420 page. It's I think a list of the firearms that are to be captured and all this, more or less. So I wasn't going to get it. I didn't know you guys wanted to look at it in that level of detail. Yeah, but if you can talk about, if you can continue, that would be appreciated.
Oh, sure. Yeah, no worries at all. Thanks, Rob. Yeah, so I put it in there. It's gathered a lot of news over the course of the last few weeks. it dealt with an amendment at the committee level to change and add particular weapons that were going to be prohibited under the regime. The weapons, the question that became obviously is that were these weapons, including hunting rifles and handguns and other types of firearms that a lot of Canadians thought that would impinge their rights to the firearms and their use of them. So the Conservatives who have always objected to curtailing use of firearms, particularly long guns, took the position that there was a great overreach by the amendment to the legislation in committee, and the minister tried to basically make it clear that there was no intent to include firearms for hunting purposes primarily. So that wasn't the intention. So that's why I provided a link to the CBC article on it. So it's there for informational purposes. Does anyone have any input regarding this issue? All right, so we'll let it take its course. Yes, Brennan.
Sorry, Miles, just really quick, just a really quick observation. I find this interesting a little bit. I'm not a gun enthusiast myself. I'm not an expert in them by any means, but if you recall that brief I presented last summer in the previous parliament about rural crime, I think there could be some really interesting overlap just because of we talk about safety and fear of crime and all that in rural areas and why we need to change things. So I think there could be some unexpected complications or unexpected consequences on approaches to rural crime should this bill pass in this form with that amendment and everything.
Very good, thank you. Yeah, all right. So yeah, absolutely. Let's keep track of it and see where it goes and see what the impact is. Howard.
It's astounding to me that regardless of repeated attempts to clarify by the Minister of Public Safety that this is still being branded as outlawing hunting weapons. And so the negative response to this latest round of government initiatives on firearms is quite astounding to me. They've lost the public opinion conversation about it. It really is being seen primarily as an attack on hunters and legal gun owners. So I find that interesting. I don't know enough about the weapons myself to distinguish between automatic, semi-automatic, hunting rifles and shotguns and all of that. But I think the federal government's losing the public image debate on this one, which again, I think lends itself to Brendan's thought that it connects a lot with the difference in how the criminal justice system operates or is accepted in rural areas as opposed to municipal areas. And there's some interesting data from Stats Canada that was in the last newsletter about, is it the last newsletter or the upcoming one? Sometimes they all start, upcoming one, yes. There's a Jurstat bulletin, a quick fact, firearms and violent crime in Canada, and it highlights, Brendan, an astounding difference between gun crime in northern rural areas versus urban areas and versus southern urban areas, which is lower than the northern by an immense amount. But we'll have that in the newsletter. Stats Canada seems to be doing a lot of stuff right now. We had 2 items in last newsletter. There'll be 2 items in this. I'm suspecting that they have data that they're trying to get out before year end. But as Irving and I have sort of commented back and forth to each other, they seem to be, there's a lot of Stats Canada stuff now. So keep an eye on the newsletter because it's all interesting. There's one on victimization of youth that's coming up this coming week as well. So stay tuned.
Yeah, thanks, Howard. And I agree with you. Bill C-21, I think, it's an incredibly laudable proposal, but fraught with political landmines. It really is a no-win proposition. No matter how the Liberals want to frame this, there's going to be an enormous amount of pushback against it. And I agree with Howard that the PR battle is being lost on this issue, which is a shame because, and again, I'm not a gun enthusiast either, although I do have brothers-in-law who are very much hunters, and they take this stuff, they take it as a personal assault to their way of life, and you'll never convince people to move off that to a great degree. I mean, we're not we don't deal with the NRA, and we're not the American second right in the Constitution kind of thing. But boy, there's still a lot of that kind of rhetoric that is out there. So again, Howard said it, he's quite correct. The PR battle is being lost. Does anyone have anything else to add to this particular conversation? We'll see it as it unfolds. I received a note from Peter when he advised that he couldn't attend today, and this deals with the Alberta government's desire to institute an Alberta Police Service. And he indicates that he started the edits of his essay on the Alberta Provincial Police Initiative for the Justice Report. I know there's been discussions in that regard. It'll be ready to be sent before the end of this month. He says, interestingly, the new UPC government is now pushing for an amendment to the Police Act to allow the province to appoint police commission members for the urban services that have police commissions. However, this will not have any impact on the RCMP. So he's preparing that, and I'm sure we'll be able to see it if the Justice Report is published before our next meeting. And if not, he'll certainly, give us his rundown on his report at that point. Okay. Any other issues? Any topical issues that we should be discussing at this point? All right. If we can move to business arising, we'll do the updates on the justice related committees. The first one is the Commons, Justice and Human Rights. So that's Howard.
Thank you, Miles. So just in terms of an overall view of it, there have been 9 meetings of the Justice Committee since our last PRC meeting on November the 8th. 3 of those meetings dealt with Bill C-28, which was the government's response to the SEC decision having to do with self-induced extreme intoxication. I'll come back to these in a little bit more detail. There was one meeting, just one meeting on Bill S-4. Long title is an act to amend the Criminal Code and Identification of Criminals Act and to make related amendments to other acts, round bracket COVID-19 response. This is sort of a modernization bill. And I'll come back to that in a minute, but it's primarily procedural and having to do a lot with electronic processes and procedures in criminal trials. There were 2 meetings on the government's obligation to victims of crime. We've talked in the past about that study, and I'll come back. The study is concluded with a report, and I'll come back to that briefly. And there were 4 meetings on Bill C-9, an act to amend the Judges Act, having to do with the process for review of complaints against federally appointed judges. There are no future meetings currently scheduled, so I don't know offhand whether or not they'll meet before the new year now. We're pretty late into, I think there'll be a rising for the holiday season pretty soon, but we'll see, and I'll keep an eye on that. Now, let me give you just a little bit more detail. You'll remember on the C-28, which is the government's response to self-induced extreme intoxication. The odd thing about the committee reviewing this is that the bill has already passed and received royal assent. This was pushed with great urgency by the federal government and the Minister of Justice. The order of reference to the Standing Committee was on June 21st, but the bill actually passed on the 22nd and received royal assent on the 23rd. So very shortly after it was referred to the committee, it was already passed, but the order of reference still called on the Standing Committee to report back to the House after reviewing it, the issue, reviewing the bill, to report back by December the 16th. So as of yesterday, December the 12th, and there are no minutes nor evidence available yet for that report, that committee meeting. They considered the draft report. My assumption is they'll be sending that off to the House very shortly. So remember, this is the Supreme Court of decisions in Brown, Sullivan, and Chan that struck down 33.1 of the Criminal Code as unconstitutional. It prohibited the raising of the defense of extreme intoxication in cases where it's relevant. And that would, in the law, that would only be cases of specific intent, murder, sexual assault, not cases of general intent. So the bill is already passed. It's not clear exactly why the committee's looking at it now, but we'll see. The actual bill itself, what it proposes to do is, or what it does, or purportedly does, I guess it's passed now, is to provide that those who are criminally negligent in voluntary consumption of intoxicants can be held liable for the harm they cause to others while in that state of extreme intoxication. Again, a little bit of an odd communication game. Criminal negligence causing harm or death has always existed, and so where those conditions exist, there was criminal liability. I think this is primarily so the government can say that someone's charged with sexual assault. There's another way to deal with extreme intoxication or charged with murder, so that we don't end up with the court saying extreme intoxication is a defense to sexual assault. So anyway, I'm curious to see what the committee does in their review of it. Again, the bill is already passed. It seems like a backdated, retroactive review, but we'll have to see whether they can bring some wisdom to the matter. Let me move on to Bill S4, which is a government bill, but introduced in the Senate rather than the House of Commons. Again, primarily electronic procedures having to do with jury selection, telewarrants. It's a good thing generally for the government to institutionalize the use of electronic processes where possible to save people's time and to save court resources. And of course, the COVID pandemic certainly has highlighted that, and courts are experimenting with various things. This bill doesn't break any new ground. It's not a leap ahead, but one of the interesting things it contains is a provision allowing for independent reviews of these electronic processes and a subsequent review after 5 years by the House of Commons committee on these electronic processes. It would be nice if someone started to look at the real question, which is starting now to be debated in the bar, about whether a remote appearance is enough, whether that's satisfactory justice. As you may know, there are a lot of judges who still insist that they can only adequately assess credibility when they see someone in person rather than electronically. My son, who's a criminal defense practitioner, also believes that it's easier as a witness to create a certain impression when you're doing it electronically rather than in person. But that's a debate that's just starting now, pushed on by the COVID issue. And so we'll have to see where all that goes. I think courts need all the help they can get in terms of efficiency. So, and of course, S4 is at the committee's meeting on December the 12th, again yesterday, they heard 2 witnesses from the Barreau to Quebec and then went on to clause by clause, which is the final review of the bill. So in the one meeting, it's kind of, they're dealing with the bill completely. So obviously there's some pressure to move it quickly, although it has languished for a long time before Parliament. So maybe it's time to keep moving it quickly. Again, the evidence is not available. So on that, from that committee hearing, so I'll take a look back at that. The thing I want to do, the main thing I want to talk about, actually, I'm going to come back to that. Let me just deal quickly with Bill C9, Amendment to the Judges Act. This is a bill that proposes to replace the process to which conduct of federally appointed judges is reviewed by the Canadian Judicial Council. You'll all be aware that anyone can make a complaint against a judge to the Canadian Judicial Council. This is not an appeal of their decision, but is a complaint about misconduct by a judge. And we've seen some of that recently with Justice Camp, who at the time he was reviewed by the council was a judge of the federal court. But the complaints against him went back to the days when he was a provincial court judge in Alberta and told a complainant in a sexual assault case that she should just sit down on her bum and keep her legs closed, and that would prevent the ensuing sexual assault of which she was complaining. Anyway, the Judicial Council, it's really time to update these processes. They're making changes to the regular process that can lead to a recommendation for removal. Of course, only the both houses of Parliament can remove a federal judge, but the Judicial Council makes a recommendation to the Minister of Justice, who decides whether or not to put that before Parliament. But there is a process to deal with allegations or complaints that are not serious enough to warrant a judge's removal. So that's sort of a new thing. And the bill also deals with the complaint process for people who are appointed by the governor, general, and council as well to hold office during good behavior. So people like ombudsman would also fall under this kind of process. So it's an interesting thing. The bill was amended slightly in committee, primarily dealing with a report back to the complainant when the complainant is dismissed. The third reading of this bill was completed in the House, so it's now time to go on to the Senate. So if you'll indulge me, one thing that I think is probably the most important of the thing to talk about is the committee's study of the government's obligation to victims of crime. Miles, if I can just take a couple of minutes on this, the committee has released its report. We've talked about it before. I've been looking for something to tell us why the committee has taken this on, other than the ongoing popularity of examining victims' issues in the criminal justice system. I don't mean to make light of that or be deprecating, but the Canadian Victims Bill of Rights, with all sorts of other things, it seems to be an issue that's always talked about more than a number of others, in my humble opinion. At any rate, in the conclusion of its report, which was just released, it was adopted by the committee on December 1st and presented to the House on December 7 with a request for the government to respond. And I'll come back to the report in a minute. It's called Report 7, Improving Support for Victims of Crime. The report's conclusion says this: the committee pardon my tongue tripping. The committee conducted hearings on the status of victims' rights in Canada to assess the shortcomings of current legislative and policy measures available to victims of crime. So they started it to assess the shortcomings, not to find out whether there were shortcomings, but to assess them. And sure enough, they found gaps and shortcomings. I have a particular perspective on victims in criminal justice, and so that you'll be hearing some of that. And I'm a little bit skeptical of all the talk. I find the report, which has 13 recommendations to it, disappointing. Disappointing in two ways. One of which it recommends things that are not likely ever to be implemented by the federal government, and in some cases it recommends things that the federal government do that aren't even in federal jurisdiction, strictly speaking. And again, it's a lot of the common verbiage. So we talk about, one of the recommendations is to establish an FPT working group to establish national best practices and minimum standards. Not that that wouldn't be a good thing to do, it just would take a lot of time. There's variation that exists in the provinces and territories because it's an administration of justice issue as much as anything in terms of the services and support. So another FPT working group, I don't know. They're proposing to amend the Canadian Victims Bill of Rights to establish a right on the behalf of the victim to receive assistance and support. Well, what does such a right look like? Who's it enforceable against? What does that mean? What does that mean in Newfoundland? What does that mean in Yukon? Andrea may want to jump in on this, or NWT, a right to access support and services where they're not provided by a province or territory, where they're not funded. Does the federal government now have to fund them, and to what level? They raise serious questions. There's the perennial increased funding recommendation from the federal government. And again, that would be competing with all of the other things the federal government's spending its money on, or people want it to spend its money on. Automatic provision of info. So under the CVBR, the Canadian Victims Bill of Rights, the victims are entitled to certain information. This is a provision that would require that information to be given to them automatically rather than on their request. And so I'm cool with that. But again, how's it going to work? And this would be instructing presumably the Crowns. It would change some of the nature of their job. One of the recommendations I love, 8, is recommendation 8 is to expand and adequately fund restorative justice's processes. Well, I'd love that. I don't think the federal government has ever seen that is their responsibility. I think the federal government sees it as a provincial territorial responsibility. The funding for restorative justice's programs, as Brendan can tell you, is sporadic and difficult, and there is no sustaining funding from either level of government. There's a little bit more from the Ontario government, and Ontario very little from the federal government. And as one of our colleagues at the Collaborative Justice Program likes to say, the federal government is usually involved in death by what does she call it, Brendan? Death by
piloting, I think.
Death by pilot. Death by pilot.
Yeah,
so
death by
pilot
pilot.
funding from the federal government that would last for 6 months or a year and a half, and then be cut off, and the organization is left stranded. So anyway, but I'd love it if the federal government wanted to adequately fund and restore restorative justice processes throughout the whole country to a certain level. But I'm not holding my breath that's going to happen. There's a recommendation to examine the parole board processes, the federal parole board processes, to make them more conducive to victims and family participation. I mean, Irving will tell you this is an issue that's been alive for decades. I think the parole board has made some real great gains on this. How much is enough? I don't know. Anyway, the biggest thing, and you've seen some of this in the media. In fact, we had an article in the newsletter on this, on the newsletter of December 11th, so this Monday, on the publication ban issue. As it turns out, I mean, I'm not an expert in publication bans. Some are mandatory, some are discretionary. The judge and the Crown, and almost inevitably in sexual assault or intimate partner violence or family violence, impose a publication ban. This is a good thing that's worthy of discussion. A number of victims are saying, I want my voice to be heard. I don't want to be protected in a paternalistic way. I should be asked before a publication ban is imposed. The Crown and judge shouldn't be proceeding to do this. And if I wish at some point to waive the publication ban, I should be able to do so. That's not flexibly and regularly available in our system. And so one of the things I like is this recommendation 11, that victims must be informed before a publication ban is imposed and given the opportunity to opt out at any time in the process. Francois may have something to tell us or say about this in terms of his prosecution in Quebec, but I think that's a conversation that needs to be had, and something that's worth focusing on. I think victims, it should be up to victims. I don't think we should be protecting people in a paternalistic way. But at any rate, I have the report in PDF, and I have a link to it. It will undoubtedly be in the minutes for this meeting, which you won't see for a while, but I'd be happy to send to anyone who wants the PDF report and the link. So just let me, just to show hands, how many people would like it? I can send it to all of you. Lynn, Andrea, I can't see Rob, I can't see, I'm gonna send it to all 10 of you. And you can, I'll just send a link, or Miles, do you want me to send it to you, and then you can send it to everyone on the PRC?
Absolutely, that's a good idea.
Good. So I after this meeting, I'll send to Miles both the PDF report and the link to it to distribute it. Have a look at the report. I'm hoping I'm being a little bit too cynical. I worry about the confusion between what the justice system can do and the real need for support for victims, which the justice system was never designed to do, and is a very poor platform or structure for support and assistance to victims. But anyway, that's my 2 cents worth. Apologies, Miles. I'm going off at great length.
No, it's great.
I'm
Thank
going to
you.
stop there.
Oh, thank you. All right, Howard, appreciate that. Any questions or comments? Oh, Brendan?
Yes, I just have one really quick comment about Bill S4 that Howard was talking about. I just wanted to mention that, so Howard's right, it is a modernization bill. It's not really treading new ground exactly as Howard says. One thing I just want to be hesitant about, and it's something that was in the bill, and I don't know if it was a great idea, it's sort of predicated on this idea that this bill will help make the system more efficient. When I presented with Cheryl Webster at the Senate, I think we both sort of feel it's a very dubious claim that this bill will actually make things more efficient. It's more when we're looking at expanding access to virtual appearances and whatnot. we can't really see the mechanism for things going faster. We think the argument is more of an access to justice issue where certain people might be able to attend more easily and from far-flung places. So we think it's more of an access to justice thing, and we hesitate to couple efficiency with that bill. At least we're talking about in court efficiency. I'm not sure about, because I think there's issues about telewarrants. I'm not an expert in that by any stretch. But yeah, I just wanted to make that observation.
Thanks, Brendan. Anyone else? All right, very good. Let's move on to public safety and national security. That's Rob.
Good afternoon, folks. Thanks, Miles. So CQ met 6 times since our last meeting. 2 were concerning the assessment of Canada's security posture in relation to Russia, and 4 were about Bill C-21, which we discussed at the beginning of this meeting here today. So I wasn't going to go into great detail about C-21. You have the, let's say, correct observation that there's mixed feelings about this bill from all kinds of folks. The committee is at the stage of clause by clause review. The last 4 meetings were of that nature, with the assistance of Department of Justice officials, as well as DPS and our Department of Public Safety and RCMP policy representatives and firearms experts. So they also have a meeting scheduled today, requested by 7 members of the committee to discuss their request to rehear from certain witnesses regarding some of the proposed amendments. So yeah, mixed feelings about the bill among individuals and groups who are concerned about this. All I can say is after reading the materials, you know, the testimony, folks are giving examples of, let's say, and they're logical and reasonable examples of where there's some, let's say, deficits or problems, in their view, problems with the bill. I'll give you a couple, and there doesn't seem to be a great response to these concerns either when you hear them. So thus the perhaps losing some support of those who are following this bill. So let's take farmers, for example. There's a concern in certain parts of the countries about wild boars. Some of these folks use semi-automatic weapons to deal with this issue on their property to protect their livestock. So you have, you know, example there. Some bird hunters use semi-automatic weapons. You have bow hunters who may be using a bow when they're hunting. It's a bow hunt, but they'll have a gun nearby to protect themselves from seeing something worse than that, such as a bear. So these are reasonable things, reasonable concerns, and believable things. They're not just made up issues because someone doesn't like the bill. And they seem to, there doesn't seem to be a great response to those concerns when they're raised. The other thing that was came up in a meeting that I checked, the evidence wasn't available for our last meeting in November, but one of the association raised the issue of the raising of a penalty for firearms trafficking from 10 to 14 years. And that person made the point that, you know, I don't know if it was a fact or not, but what that person didn't know was if this was a fact, that no one's ever been convicted of firearms trafficking and received 10 years. So what impact is that going to have to raise that to 14? It's pointless in that person's opinion. So these are some of the issues. These are some of the things that are raised at these meetings, and you can see why there continues to be mixed feelings. And that's about best way I can summarize this what's going on with this bill at this moment. So I'll stop there. If there's any questions, feel free.
Yeah, thanks, Rob. Any questions or comments?
I'll maybe just make one quick comment, if that's okay. Rob, I take your last point. I think it's very interesting. Yeah, the idea of raising maximum penalties and all that. I think that's something that I think we've all seen the government do before. And I think, at least in my point of view, I think it's just as that witness said, it's kind of maybe a fruitless exercise. It's more symbolic than anything. So at least that's my personal opinion, since those maximums are rarely actually used.
Thanks, Brendan. Okay, let's move on to the Senate. First, we have Legal and Constitutional Affairs. Brendan, you might as well keep going.
There we go. So the Legal and Constitutional Affairs, they've been quite busy. They have met 9 times since our last meeting. They met principally on I think 7 of the meetings were on Bill S 205. 2 were on the issue actually that Howard was speaking about as well, about C28 with the issue of self-induced intoxication. I won't go too much into that, given that Howard discussed that quite thoroughly. But at least in terms of Bill C-205, it was a private member's bill raised in the Senate. It's essentially a bill to address issues with intimate partner violence. Interestingly, there seems to be a kind of like a twin bill coming through the House of Commons, Bill C-233, if I'm not mistaken. That's not yet. I think it's just reached second reading at Senate. It has not reached committee yet, so that's sort of colored how the committee proceedings have gone on Bill C-205. Sorry, S-205. I apologize. So Bill S-205, it essentially aims to increase the use of electronic monitoring. Among other things, it seeks to allow police officers to release individuals with electronic monitoring without them having to go to court. It also seeks to add another section, essentially a new peace bond under Section 810 of the Criminal Code, with higher penalties. Not being a lawyer, my reading of it was that it was essentially the same as 810, except for the wording was more specific to instances of intimate partner violence, and the penalties for non-compliance with it were also greater. Penalties also for not entering into the 810, I think, were also possible. There was quite a bit of testimony on this. As I said, I think there was about 7 meetings on this one bill. Many witnesses were heard. There were quite a few victims of intimate partner violence, different professors, and of course the Justice Minister testified. All in all, the different sides of it appeared to be, most people appeared to say that the goals are laudable. Of course, decreasing and ending intimate partner violence is, of course, of the utmost importance, but they were unsure of the feasibility of the bill. The aspirations were perhaps a bit too great. There were also concerns that we should not be allowing police officers to unilaterally impose electric monitoring, and that should rest in the hands of judges or justices of the peace. What I found actually quite interesting, there were 2 companies that provide such services across the country for electronic monitoring, and both of them appeared quite, they didn't seem to try to inflate the possibility of their technology. They mentioned that, of course, in certain areas, they don't have a great range to monitor somebody. So somebody might be within a 1.5 kilometer range. They know they're in a general area, but they can't pinpoint them closer to that. One issue that was raised was that, of course, if you're on a reservation or something like that in northern parts of whether it be Alberta, Ontario, etc., that some reserves are only about that large. So it's functional. Functionally, it doesn't do much. The representatives of the companies with this technology also mentioned that we really need to temper our expectations of what the technology will do. They said, is the expectation that we stop an imminent attack, or is the expectation that we notify when there's some sort of breach? So because one thing that several victims mentioned was that, and this seemed to be sort of the other side of the debate, where victims were saying, if I had have known that my ex-partner was in the area, I would have left. If I had have known, I could have called police and I would not have been a victim of assault afterwards. So that was kind of their argument and why we should expand the use of the electronic monitoring. However, it seemed that the actual functional limitations were greater than we thought. So those were sort of the main arguments. they proceeded through a clause by clause consideration of Bill S-205. There were concerns that again, that these sections were essentially repetitions of other sections in the criminal code and that they weren't actually necessary, that provisions also already exist. I admit that that led to some what I would consider some acrimonious debate in committee. In the end, I believe that an amendment was tabled, or an amendment was tabled. I was unable to, it was a little bit confusing in the transcript and I couldn't find a new version of the bill, but it appears that they amended the bill so that police could not unilaterally impose electronic monitoring, that it did have to go through a judge upon the request of the Crown Attorney. So that seems to be the only amendment that stuck. One observation that was quite interesting was Senator Kim Pate mentioned, again, wanted to put it in an observation that, of course, intimate partner violence is an important issue, but that this bill might be repetition and it might not achieve the ends that we wanted. In the end, that observation I don't think made it because some senators thought that that was essentially saying that the bill is useless as they were passing the bill. That's it for S-205. One quick thing I would mention for the self-intoxication provision in C-28 that was changed. Again, there was concerns that it was pushed through, as Howard mentioned. One concern that I thought was particularly important was that because, as Howard mentioned, the new provisions that if somebody has ingested drugs or something, or was reckless in their taking of drugs, or other intoxicants, that they could still be held accountable. But people were saying that because these situations are so rare, how can we know what being reckless is? Because nobody really uses. People could say, "Oh, it's my first time taking drugs. How would I know that would have happened?" But people could say, "I use drugs all the time. That's never happened before. So how could I have known?" So some people are quite afraid that we're not going to be able to establish recklessness in taking of intoxicants. But I've went on a little longer than I wanted, so I'll just leave it there. I believe the committee is going to, they're actually meeting this afternoon to continue the discussion of extreme intoxication. But the goal, I think, is to put some report back to the Senate, but that's about it for me. Thank you.
Great job, Brendan. Thank you very much. Anybody have any questions or comments? Yes, Howard.
Howard, you're muted.
At least I remember to mute myself, which is a good thing. I forget to unmute myself. I think my wife would be happy if I did that all the time. But so in the trilogy of Supreme Court of Canada cases that struck down the provision preventing the defense of extreme intoxication, Brown, Sullivan, and Chan, in none of those cases would anyone be found criminally negligent or reckless. They were all odd circumstances, combinations of drugs or and a suicide attempt at one point. I mean, it's so this, and the forensic experts tell us that this is a very extremely rare kind of state of mind, notwithstanding the fact that 3 cases all came together at the Supreme Court of Canada. It's statistically quite rare. But the other thing, Brendan's report was really good, but he highlighted something I find very interesting, and that is the whole issue of private members' bills. So they are a very strange and unique thing that have gained power over the last number of decades in the House, particularly under the Harper regime. But when I started many years ago, they just almost never survived. The question is how well they're drafted, and sometimes they create a lot more harm than good. Just if you're interested, have a look at the newsletter. And I'm not selling the newsletter. I don't get any commission for it. But one of the items in last week's newsletter is called Scrutinizing Private Members' Bills. And it gets exactly into this. It talks about other bills than criminal justice, but John Mark Keyes, who was the chief legislative counsel for years in the Department of Justice, is quoted quite extensively. He teaches at the U of O Law School, but it's a very interesting area how these bills come forward. And as Brendan's report clearly indicates, some of them are not at all well drafted and without regard to what's already in the criminal code, but they become sort of politically correct speak. And so no one wants to vote against them. But if you can, go back to the newsletter and have a look at this article. It's quite an interesting one. So thanks.
Thanks, Howard. Anything else from anybody? Okay, thank you. All right, so it's up to me now. We're dealing with the Senate Committee on Human Rights. So the committee has had 5 meetings since the last PRC meeting, 3 in November, 2 in December. The 2 in December were in camera, and I'll talk about that in a few seconds. The committee continues to basically focus solely on Islamophobia. It includes that with respect to online and offline violence against women, gender discrimination, discrimination in employment, and Islamophobia in the federal public service. And it also studies the impact on individuals, including mental and physical health and safety, and possible solutions for the government. So what is happening now is the committee is meeting in camera to discuss a draft report. So I don't have that available at this point, but clearly when the report is released, I'll come back to us, the PRC, and discuss the findings in the report or recommendations. All right, so that's it for that. Any questions about the Senate committee? All right, everybody, thank you. Further business arising. I'm not going to touch on those things that are still waiting briefs. They are included in our agenda, and they are continuations of our prior meeting and agendas. The one item that, or a number of items that still has some activity on them, we have the meeting of December 7th with respect to OPC advising. It says Peter and Lynn will be reporting. Lynn, do you have anything to say about that particular item? It's the item on.
No, nothing new to report. I'll after this call, I'll sync up and hopefully we'll have some news, some status for the next call. Thank you.
Thank you, Lynn. Appreciate it. Going forward, the proposal that I'm dealing with respect to provincial support for unifying criminal records as a ground for discrimination under all the individual human rights codes across the country. I'm still researching it. I plan to have for the next meeting a comparative analysis of jurisdiction to jurisdiction, so we know exactly what we're dealing with. So I'll present that on January the 10th. That moves us to bills under consideration. So we'll just touch upon the ones that have had some movement since our last meeting. Bill C5 has royal assent. We did spend a lot of time discussing this bill. Now that it is law, we'll remove it from the list of bills. Bill C, any comments on that? Bill C9, Howard's already had his comments about that. That's the act to amend the Judges Act. I indicated there was no change, but Howard tells me it's had 3rd reading. So I'll change the agenda to reflect that. So I apologize. Bill C21, we've discussed it. So I don't think there's anything to add in that regard. That's it for the public bills in the Commons. The private member bills, we have no changes in the Commons. Senate, we have the government bill, again, S4 that Howard has discussed regarding the identification of criminals and electronic efforts in that regard. It is now at 2nd reading. Brendan mentioned private members bill S205. I didn't have that on the agenda, Brendan, so thank you. I will add that to the agenda. So again, my apologies. Bill S206, that's disclosure of information by jurors. It's now had royal assent, so it's been enacted. Bill S224, these are the private member bills in the Senate. S224, that's the amending the code dealing with trafficking in persons. That's had 2nd reading. And there are no other changes to any bills, public or private, in either the Commons or the Senate. Does anybody have anything to add regarding any of the bills that are on our agenda or have been discussed?
It's Rob. If I could ask a question, just don't know the answer. I was just wondering for my own self. So for a private member's bill, let's take Bill S212, the one regarding expiry of criminal records. So that's been sitting, it went through 1st reading in the Senate, and then it's been sitting around doing not much, nothing, it seems, to, I guess, the average person, myself. So what's happened? What's like for in that, as using that as an example, what's happening with that? If nothing at all, or is it forgotten, or is it, yeah, just curious.
Yeah, well, obviously what I do is in preparing for the agendas, I go through legislative information, the website, and try to update the status of all the bills, for instance. And again, this one, like many other ones, so that particular bill dealing with the expiry of criminal records, and we've dealt with that a lot, at the PRC. But in any event, it had its first reading of November 24th, 2021, so over a year ago, and there's nothing else showing in the record that there's been any more activity. So it would easily need a second reading to go forward to committee, and that hasn't happened. And that's the case with a number of bills. It's private.
Okay.
Yes, Rob, sorry.
That's
Yeah,
Kim
just curious, is
Pate's
it
bill, isn't it?
dying?
No,
Sorry,
it's
go ahead.
still on the order paper. Irving?
Okay.
I was just saying, that's Kim Pate's bill, is it not?
Yes, it is. It's her latest bill with respect to implementing a spent conviction
Automatic
regime.
expungement.
Yeah, which we've talked about. We have a
And
report
the
on
history
that.
is even, I think, Miles, the history is even longer, if I'm not mistaken. That's a follow-up to a previous bill that she had.
There are at least 3 previous bills.
A long history.
That have dealt with it, and Kim Pate's been the mover of almost all of them to a great degree.
Yeah. Yep.
But it's again, nothing has happened on it. Yes, Howard.
Just to add that the history is replete with bills, private members' bills that have been introduced in every session in every parliament going back a long time. They tend to be private interests, particular interests of the particular MP. There's nothing much pushing them forward. Miles, have a look at this article, as I was mentioning in last week's newsletter. But they're subject to a very variable fate. In the House of Commons, there's a lottery system that was established. So if the bills are chosen in the lottery, and only a small number of private members' bills are chosen out of the huge number of private members' bills that are introduced, if they're chosen on the lottery, then they will be allocated so much time of debate at second reading. This lottery system, which was relatively recent, i.e. now probably about 2-3 decades ago, gives them a chance, at least in the House, to get pushed on. In the Senate, I think it's even a different matter. It's a question of how much support they have. So only those bills that manage to glean widespread support in the particular chamber move forward, and not many private, historically, very few passed. These days, more pass. Under the Harper government, you may remember, the Harper government, instead of introducing a policy on criminal justice, would get a private member to introduce a bill on it, and if it was successful, the government would adopt it. Now, the government can still do that. If they adopt a private member's bill, either in the Senate or the House, they can support it, and it will move more quickly because of their majority. But many private members' bills are a peculiar interest to the MP or senator, and they often use it to show their constituents that they're bringing an issue forward to the floor of Parliament. Many of them are very, very poorly drafted and ill-considered, because the private members generally don't have the resources to put together the policy or draft it in legislative form. But they're always extremely variable. Harper's government gave a real life to it, and I think any government, this John Marquis is of the view that Chrétien was the one who started getting more attention to these bills, because he had a huge majority and sequential majorities, if I can put it that way, where a number of the members couldn't be cabinet posts or parliamentary secretaries, so he emboldened them to make them feel that their private members' bills would go forward. But the quality is highly inconsistent. Rob, does that help at all in terms of the history of them?
Yeah, yes, it does. And thank you to everyone for pitching in to just give me a bit more info. I found it curious that there was some momentum there. Let's say a couple of years ago, there was Irving, I remember that. Before that, some momentum with a previous version of the bill or previous bill. And then there seems to get to a stage where I believe the PRC wrote about this issue,
Yes,
if I recall correctly. And then it seems like, it just sort of things stopped, and it felt like nothing was moving even 1 millimeter. So I'm just curious of what what kind of tends to happen to things like that. And if there's, chances for movement forward or, what's going on. So anyway, all of that helps. So thanks very much, guys.
Good. Thanks for your question, that Rob. That's great. Anything else, anybody?
Miles, I just want to make one quick little note about bills that are coming up. At least I don't know if this is one that would be very interesting for the PRC, but the Standing Senate Committee on Legal and Constitutional Affairs, they're going to be examining Bill S11, which is about harmonizing federal criminal law, I think, with civil, or sorry, not federal criminal, but just federal and civil. So maybe that's one to add, maybe it's not, but I just wanted to flag that.
Yeah, thanks, Brendan. I'll make a note of that and take a look at it and see if it should go on the agenda. So I appreciate that. So it's S11.
S11, yeah,
So it's a government bill.
I think it is, yes.
Okay, thank you. I will take a look. Anything else, anybody? All right. Well, listen, that was a wonderful meeting. Thank you, and all of the very best of the holiday season to everybody, you and yours.
Right.
Have a wonderful.
Enjoy, stay safe, everybody.
Thanks,
Absolutely.
everybody.
And we'll see
Take
everybody in
care.
the new year.
For sure.
All the best.
Thank you. January the 10th
Bye.
is our next meeting. Take care.